Patel of Legacy Law PA here on behalf of Buckley Towers Condominium. This video is a short one just to give you a little overview on how the Kaufman language is applicable to the Buckley Towers condominium. The Kaufman language essentially is language that's found within any declaration that states that the declaration and thereby the association is governed by the Florida Condominium Statute as amended from time to time. And that as amended from time to time language is the key language known as the Kaufman language, which would incorporate any changes to the Florida statute to the declaration retroactively. And now the decision from the Kaufman case has created a lot of confusion and a lot of cases that came through after that case was decided on different scenarios on when it is applicable and when it is not. Essentially, the court has laid down a test to determine whether or not the Kaufman language will come into play and whether or not a Florida condominium statute can be retroactively applied to an existing condominium. The Buckley Tower Association does not have the Kaufman language within its declaration. So what this means is that any amendments to the Florida condominium statute do not automatically get applied to the unit owners and the association. What does get applied, however, as the courts have noted, most recently in the Tropicana condominium case, is that procedural laws, meaning laws that simply outline or provide a framework on how and when duties and rights of particular parties to a contract are applied, those do get incorporated into a declaration. However, any substantive changes to the law, meaning any laws or amendments to the Florida Condominium Act that would change the ownership share, the share in the common surplus or common expenses, things that affect the substantive rights of unit owners or the association, those changes cannot be imposed upon a declaration of condominium incorporated into it retroactively. And the reasoning the court has given is the Florida Constitution Contracts Clause. And what that says essentially is that the legislature cannot impose or affect the substantive rights of any parties that are in an existing contract. And here the existing contract is the declaration and the bylaws of the association. Some examples of procedural laws are how a condominium may be terminated, how unit owners may request records, the percentage for quorum, for meetings, and things of that nature. So things that provide a timeline, maybe in a percentage on how things should be conducted procedurally for an association. And again, these are not blanket applications. These are case-by-case basis, but this is the framework that should be used and applied with respect to the Kaufman language. If you have further questions on how this affects the Buckley Tower, you can direct them to management or to the board of directors for any clarification that you might need. Thank you.